Good afternoon. Today I want to say something about an important recent case in the full Federal Court, Curtis and Singtel Optus Proprietary Limited, 2014 Federal Court of Australia Full Court 144, which deals with a very important practical question in terms of bankruptcy, which is whether or not you can issue and attach an electronic bankruptcy notice, I guess, whether you can attach a final judgment or order as required by the rules electronically. This is all the new system, of course, being introduced, and we've got a decision of the Federal Circuit Court of Australia, 2014 Federal Circuit Court 1286, which decided you could, and now we've got Justices Mansfield, Gleeson and Beach looking at an appeal from that decision. And we're dealing here, of course, with a Section 41G matter, where you need to have a final judgment, which hasn't been stayed to be served the bankruptcy notice, and bankruptcy notices requirements are set out in section 41 of the Act, and then we've got various regulations, regulation 401 and 402, which talk about serving with the notice a copy of the sealed or certified judgment or order for more than $5,000, which empowers the court to make an order pursuant to section 52. And the issue here is whether or not, under the new regime, having issued an electronic notice and then attaching an electronic copy of the judgment, whether or not that was sufficient compliance. And related to that, as usual in these cases, was the question of how section 306 of the Act, which picks up a formal defect or irregularity, which doesn't mislead the debtor, whether that applied or was relevant. Now, how does it all work? Well, the official receiver intervened to protect his new method of operating, which must cut down a lot of paperwork and time. And the way in which the new system operates is set out in paragraph 15 of their Honour's judgment. And what happens is this, in terms of electronic issue. The creditor registers its details with the Australian Financial Security Authority, the AFSA, which is now the government agency responsible for administration of personal insolvency, and gets access to the online services on its website. Creditor logs on and submits a bankruptcy notice for approval using the online services. Creditor is required to complete a number of fields which correspond with the details required by Form 1 in the regulations. First screen requires the creditor to complete details of the final judgment or order of the court upon which it relies for issuing the notice, and the creditor is then required to upload a copy of the sealed or certified final copy judgment or order evidencing the debt owed by the creditor. Okay, so creditor reviews the online application, submits it online, including a draft copy of the bankruptcy notice. Creditor pays the prescribed fee, and upon receipt of the application, a delegate of the official receiver reviews the online application, checks everything's tickety-boo, and if it all appears to comply with requirements, the notice is approved and endorsed. Upon approval by that delegate, the system automatically generates a covering letter to the creditor and a bankruptcy notice in the prescribed form containing details as entered into the online fields, and the system then automatically creates and sends an email to the email address supplied by the creditor with its application. Oh dear, imagine opening that email. Attached to the email is a covering letter, the endorsed bankruptcy notice, and a copy of the final judgment, which the creditor uploaded with its application as documents in PDF format. And the system inserts into it a unique bankruptcy notice number, issue date and signature in the office use only field. So there you go. And in this particular case, that system was followed, and the notice issued, and the Federal Court Magistrate, Primary Judge, the Circuit Judge I should say, not a magistrate anymore, held that paragraph 19, the electronic mode of issue of the notice adopted did not strictly conform to the relevant provisions if they were considered in isolation with the Act and regulations. But if the Act and regulations were considered with the Electronic Transactions Act 1999 of the Commonwealth, then the electronic mode of the bank issue of the notice adopted by the official receiver would conform to the relevant Act and provisions, regulations. Third, there was an electronic attachment of a copy of the relevant judgment at the time of issue. Fourth, in any event, on one view of His Honour's analysis, it's not a requirement to attach a bankruptcy notice at the time. And then fifth, that there was a defect, section 306 operated to overcome the problem. Well, full court looked in detail at all the acts and regulations. We won't worry about that. Question essentially was whether or not there was a copy of a judgment which was attached on the issue of the bankruptcy notice. And their honours held that attachment is, as they said, a foundational element of the court's jurisdiction. Detailed discussion by their honours of paragraphs 29 and following. And they point out that the final judgment order is it's a foundational element. Nice expression, foundational element. So much is made plain by sections 41.1 and 41.3. Paragraph 41G reinforces the point, and it requires identification of the judgment as a condition of issue, and that's a fundamental substratum of bankruptcy. And the steps that a debtor must take to extend the time for compliance requires identification of the final judgment or order. Secondly, the official receiver's administrative act in issuing it requires an identified final judgment. In the absence of that, you wouldn't be able to ascertain the foundation of what the OR is doing. And thirdly, the Form 1 is not comprehensible without a final copy being attached, because on its face and without the final judgment or order, it would not provide to the reader, including the debtor, details of the principal debt. And a reader of notice at the time of issue, including the debtor, could not make sense of a notice without such attachment to work out the debt relied upon. One purpose of bankruptcy notice must serve as to convey to the debtor how a debt that is alleged to be owing is said to have arisen. Right, and it would enable the debtor to take the various steps referred to in paragraphs 4 and 5 of Form 1. So, in our view, it is necessary to make sure that a final judgment or order is attached, and they look at the various authorities that make that clear. Paragraphs 35, 36, 37, it's got to be in a form prescribed. But question, of course, as to whether or not it was relevantly attached at the time of issue. And that's a tricky point, because it's very difficult when you think about it to see how you can attach something that's electronic. But I guess it's Res Sextantibus, or in pari materia, we're looking at a contextual sort of interpretation. And paragraphs 43 and following, their honours conclude that sending an electronic notice, no one contended it couldn't be a method of proceeding, but paragraph 47, the real issue turned upon the question as to whether a copy of the judgment was attached to the notice, by such a copy being one of the attachments to the email along with the notice and accompanying letter. Clearly all three documents were attached to the email. The question was whether two of the three PDFs would be considered as being attached for the purposes of compliance with regulation 4.02. Well, they conclude no problem. First, it seems, paragraph 48, that regulation 16.01 arguably been issuing the bankruptcy notice by electronic transmission, so you can send it out electronically. Secondly, when you look at it, we're looking at the question of whether it is attached, and attached doesn't necessarily mean physically fastened. Paragraph 51, the question is whether the PDF of the copy judgment could be treated as attached to the PDF of the bankruptcy notice, both being attached together with the letter to the email. Now clearly they were both attached to the email. The question is whether they were attached to each other. In our view, paragraph 51, they were so attached. They were attached to the same email and electronically proximate to each other. Both were sent together rather than separately, and it's an important point. Moreover, the one electronic communication, email attachments, was not divisible electronic at the time of issue or immediate receipt. Later, of course, one could choose to separately open each PDF and print hard copies, but at the time of electronic issue, the bankruptcy notice and copy judgment were together and not separated. In one sense, they were electronically glued together. Nice way of putting it. Electronically fastened to each other. Short of the two documents being constituted in one PDF, they were as close electronically as they could be. Further, if they'd been constituted in the one PDF, then it might be argued there was one and the same attachment, one document rather than a notice with an attachment. So whichever way you went, you're at risk, of course. Moreover, the fact that each PDF was itself attached to the email does not entail that each PDF could not also be attached to each other. So in summary, the copy judgment was attached to the bankruptcy notice. Then it was said, well, don't worry, in any event, there was sufficient substantial compliance. No defect, section 306 applies. And of course, section 306 looks at the way in which we can get round formal defects in the notice. Given their conclusion, of course, anything they say about section 306 in this context is overdone, but which they point out in paragraph 58. But paragraph 59 in their view, contrary to the respondent's submissions at Singtel and the OR, if copy judgment was not attached to the bankruptcy notice at the time of issue, and there had been no substantial compliance, then the bankruptcy notice would be a nullity, and that would not be cured by section 306. Was it a formal defect or irregularity? Well, a defect is substantive and not formal. If a defect is such that the bankruptcy notice fails to meet a requirement made essential by the Act, Benson. In such a case, a notice is a nullity. What's vital? Well, attaching a copy of the judgment at the time of issue is essential, paragraph 63. So that's one reason. If it wasn't attached, an essential thing would be missing. And also paragraph 65, defect substantive and not formal if it's reasonably capable of misleading the debtor. And in our view, not to attach a copy is reasonably capable of misleading the debtor. Validity in this respect is to be determined at the time of issue, not just at the time of service. All right. Well, a neat point. Will the debtor take it to the High Court, seek special leave? Difficult to know, but I guess it's an important judgment for those practising in this area, which is a pretty formalistic sort of area after all. Bankruptcy's got quasi-penal consequences, so the courts require everything to be done strictly according to Hoyle, and it now seems that in the electronic age, provided that your PDF is uploaded in the appropriate form, then it will be relevantly electronically attached, and the person opening the unfortunate email will then be hit with a valid bankruptcy notice, which will give no doubt 21 days to comply or to extend time or to do one of those many things which you can do when acting for a recalcitrant debtor. So have a look at the case, an important case if you're working in insolvency, and well repays close reading, but I guess keeping up with the times, the decision of the court, what one might perhaps have expected, and one which will speed matters up in general terms.